Thank you, everybody, for joining us today. I see some folks just joining in here at the top of the hour at noon, talking about managed care contracting. This topic, we're going to talk about some specific terms and contracts from the preliminary stage of negotiations into the contract itself, some contract terms that appear across a wide swath of contracts, and then some that are particular to managed care issues. And then throughout the seminar, if there's anything that I talk about and you have any questions, you can put those into the chat. We'll try to address those during the seminar or afterwards. My contact information will be provided. I'm pretty easy to find and happy to answer questions about this. Since we've got an hour and there's quite a bit of material here, I want to have an opportunity to go over most or all of it. Let's get started. We'll start off with some preliminary considerations when you get into the contract itself before you actually sign, just as far as getting the form of the contracts and negotiation issues, concerns if you're already under a contract and maybe you're renegotiating or there's been some change in the provider. We had that here a couple of years ago with a large merger between a couple of groups here in Florida where two providers essentially became one. So we'll talk about some of those issues, and then we'll dig into the terms and then talk a little bit at the end about implementation and some keys for you to look at. Throughout the seminar today, you'll see some places where I put practice pointers. These are issues that I have seen come up that can cause particular problems or just things of where I want to draw your attention. Those are in the slides. Everything I want to talk about is available in the slides. I have more detailed information if you have more questions. I'm actually putting all this information together to package into a book, so you'll have it available in more detail. So when you start out with a going into a contract, this is really, again, some of these concepts are not just for managed care, but in other contracting relationships as well. When you have your negotiations starting, you're obviously concerned about the financial terms, the terms of delivery, what's required for performance, what are the finance terms. And in lawyer speak, I generally refer to these as the business terms. These are usually the terms that are pretty well set by the time the lawyers get involved in review and marking up agreements, if that's going to be part of the negotiation stage. So a lot of times the financial terms are pretty well set, although sometimes they're subject to negotiation, especially if there's going to be modifications to those terms or there's to be future changes. And then we take those financial terms, we have the standard form of the agreement from the insurer or from the company, and we take that document. And that's what we work on with a focus on some things from a legal perspective, maybe some of the legal terms and some of the issues that lack clarity or that make reference to outside documents, policies, procedures, et cetera, that we need clarification on. One of the things I often hear from clients, from non-lawyers, there's a lot of reference to a lot of contracts being boilerplate or contracts being standard form. And while that is the case, and that's the case with managed care contracts, like many others, the lawyers have, I have a whole data bank of contracts for particular circumstances, for employment relationships, for medical directors, for vendor relationships. That doesn't mean that some of those terms may not change on a case-by-case basis. And even if we're not going to modify the terms, you still want to understand what those terms are. Case in point would be your notice provisions. You need to understand in every contract what's required to give notice. This is just one of the simplest things that people flub on a regular basis. I hear a problem with an ongoing contractual relationship. Did you give notice? Did you give the required notice? What are the notice and cure provisions in the contract? Almost every contract will have this in it. Did you give the required notice and an opportunity to cure? And people don't realize that the contract itself has a provision for notice that tells you what's required, where you have to send it. Is it by mail? Is it by commercial carrier, FedEx or UPS, certified mail, email, fax, things of that nature? There's plenty of boilerplate terms in contracts. Again, they won't change, but it's still important for you to know them. So when you're getting ready to go into the contract, you have the business terms, you're going to get the standard form from the MCO, and then we're going to be concerned about some particular issues, especially if you have an arrangement already with that MCO. Have you been having a hard time getting paid? Are there unreasonable delays or denials? Are there exclusions? Are there repeated complaints that you're dealing with the company itself? Are there particular issues that you're hearing from patients or beneficiaries? If you think about the nature of the MCO relationship, the insurance companies obviously want to lower costs. And so, most of the folks that are probably on the webinar today are coming from the provider perspective, or other lawyers representing providers, but you're looking at it from the perspective of the provider, and the provider looks at the insurance company and says, the insurance company is just concerned about how low they can keep their costs. And while there is a lot of truth to that, they have to balance that with providing services for their beneficiaries. So if they get too difficult to deal with, then beneficiaries will go to other providers. In Florida, in the Medicaid system, for instance, we have Medicaid managed care. We'll talk about that a little bit later. If beneficiaries are having a hard time getting services, then they'll go to another managed care provider. The managed care providers need to keep a certain baseline of patients or beneficiaries in order to generate revenue on these contracts. So there's a balance here. And if you as the provider have particular issues going into the contract or dealing with an MCO where you're routinely seeing that you can't provide services or can't do what you need to do for your patients because of limitations in the contract, you need to address that. You need to bring it to the MCO's attention and point out the fact that, remind them that there is a duty for the MCO to make services available. And if they don't do that, if they fail to provide those services, then that's going to ultimately hurt business for them. And if they are part of a state plan, such as a Medicaid plan or something of that nature, Medicare Advantage, they could run into problems themselves. As far as renewals, if you do have an existing contract, you can figure out during the negotiation phase what's going to be the effective date of the new contract. If you're having current issues, sometimes you can, and this is another point on some of the boilerplate or some of the terms that may not have been heavily negotiated from the first time around on a contract. But I always recommend parties, and I'll put this at the end too, I always recommend it is whenever you enter into any contract, you should yourself or have someone calendar all the important dates in the contract, and everybody these days uses an electronic calendaring system. Put those on your electronic calendar. If it's a 5-year contract, put the 5-year termination date or the renewal date into your calendar. If it's a 5-year contract that has a provision that says you have to give notice in a certain time to renew, or if you have to give notice not to renew, we call those evergreen contracts. They automatically renew unless you give notice otherwise. Put those dates in the contract. Give yourself advance notice. So if the contract says it's a 1-year, 5-year, whatever the term is, and it renews automatically unless you terminate 60 days prior with notice 60 days prior, give yourself time to evaluate whether you want to continue the contract and have time to make that assessment and get notice out on time. So put a 60-day date as your drop dead date. But also put another date, maybe 2 weeks, 4 weeks in advance. Give yourself a month of lead time so you know that these dates are coming up. By doing that, then you don't have to worry about thinking about what's happening with the contract as far as renewals and termination dates. That stuff will pop up automatically in your calendar. It'll be a reminder for you and your staff to evaluate whether and if you want to move forward and whether you want to renegotiate. On any contract, managed care contracts included, if you have difficulties with the contract, the best time to renegotiate and create a new deal is when it's time to renew. If you were renewing certain types of agreements a couple of years ago during COVID, when the entire economy was in this weird place of uncertainty, you could have negotiated particularly good or particularly bad deals because of the circumstances. So sometimes circumstances present opportunities. but most certainly contracts that are coming up for renewal or coming to an end present opportunities to negotiate for better terms. So make notes of what you don't like about your current arrangement if you have one, and use that to your advantage. Then you can negotiate a new contract that has an effective date that kicks in earlier, that becomes effective at the end of the existing contract, or you can set some other date as your effective date for the new terms. Have a new contract or have an addendum that overrides existing provisions and creates new ones. So this is more detail on this issue. Also, if you're coming up on towards the end of a contract, and you're going to be transitioning in or out, or making substantial changes to the agreement, or moving in and out of a system, also consider the fact that you may have existing patients or beneficiaries who need to be accounted for. So you may need to do an extension, for instance, under an existing agreement, in order to continue to provide services and get paid while the existing agreement helps with any transition. So keep that in mind as well. If you're coming up on the end of a contract that has a hard termination, it's not going to automatically renew, or if you've given notice not to renew, you could find yourself in a situation where you're negotiating towards the very end and facing a deadline. No need to panic, no need to freak out. You just need to account for that. Don't let the party on the other side, whoever the contracting administrator or your counterpart on the other side, force you into a deal that you're not comfortable with. Just do an extension, do an addendum, some type of extension for a couple of weeks, some agreement that we're going to continue to operate under our current agreement until we get into the new agreement. Look at this practice pointer here. I use this for a lot of contracts when negotiating. I'll ask clients if they want me to look at a contract to send me something in a Word format. You'll often get it in a PDF, and the PDF is presented to you by a counterpart in a contracting relationship. In part, there's a psychological factor. When you get the PDF, it says, we're not taking any changes to this contract. The deal is the deal as presented on paper. We're just going to fill in some blanks and so forth. If I am working with a client, particularly if we're trying to figure out, one of the questions that comes up with some smaller providers and practices is, at what point do you want to get the lawyers involved? Well, if we're not going to negotiate anything, if you just need a review, that's one issue. If we're going to negotiate, there's going to be some back and forth, then that can be through the lawyers, or it can be you on your own. One of the first things I recommend that clients do is ask the other party, ask your counterpart for a Word copy of the contract. Presumably, if they've got it in PDF, they can produce it in Word. And what that does is it sends a subtle message that you intend to make comments and changes to the document. Every once in a while, the party on the other side will come back and say, we don't have a Word version, which is probably bunk, or they'll say we don't like to provide a Word copy. But they may also say, we won't provide a Word copy because we won't make any changes, and then you know what you're dealing with, and proceed cautiously from there. If you're dealing with somebody who's giving you a document, says we won't consider any changes or revisions to this, or they'll say, just make a note, make any comments to the existing document on the PDF, and we'll make the changes. That's fine too. With new PDF programs, it's pretty easy to mark up a document right on the PDF, make comments in it, and ask your counterpart to make changes. We do that all the time. And this goes, again, not just for managed care contracts, but this is really in any contracting relationship. Also, if you get a copy of the Word document, it allows you to run a compare on the Word program. If you don't know how to do this, pull up a little 5-minute video on YouTube, or ask somebody in your office to run a compare, and you can compare documents, previous documents, and see what changes have been made. It'll give you a red line version. Again, very handy shortcuts when you're negotiating. If you send a document out, by the way, in Word, and you get something back, and you know or suspect or question whether or not it has been changed, the normal protocol among lawyers and contract negotiators is to send a red line copy of the document. But if you don't get a red line back for one reason or another, you can run, if you have 2 Word documents, you can run a red line version and quickly check and see what changes have been made to the document, if any. So now moving on from some of the preliminary considerations into some of the standard terms. These are terms that affect the contract that you're going to find in every managed care contract. You're also going to find these in other contracts. We'll talk about these, and then we'll talk about some of the terms that are unique in managed care. These are some. This is not an all-inclusive list, but these are some of the main terms that I want to discuss. We'll start with the parties involved. One of the big issues is to what extent are your affiliates or the MCO affiliates parties to the contract? Are they incorporated by reference? Are they specifically named? There's different ways to approach this. You just want to understand who you're contracting with, who can provide services, who's responsible if there's a default, if there's a payment issue, if there's some other breach under the contract, to whom do you have to give notice? You want to know who you're dealing with. With large companies, they're often going to have affiliates that are incorporated into that contract. With smaller companies, it may be less clear. If you're a provider and you're part of a network, or you have, let's say you're a group practice and you have a couple of different facilities within your group, and you want to make the decision if those facilities are going to be included. Typically, you're going to want those included. You're going to specifically name them, or you're going to say also that your affiliates are included within the contract. More on the affiliates here. Again, examples such as common would be a group practice with an ambulatory surgical center. You want to make sure that any services that are provided, if you're operating under a contract relationship in the group practice, and then services are provided in the ASC, and you're billing through the ASC, and that's a separate component of the billing. You want to make sure that all of that, or at least you understand that all of that is going to be covered under the contract payment terms. All right, definitions, defined terms in a contract. This is where, in my view, this is where attorneys can really take advantage of the opportunity to shape a contract. I don't want to say take advantage of other parties, but this is where there was a term that was a few years ago from video games. They called it the prize or the donut or some. This is where the gems are hidden in contracts. Oftentimes, people will read a contract. This is the same thing, by the way, for statutes. If you ever had the opportunity to read statutes or code sections, you read it, and then if you see a capitalized word or a bolded word, that typically means is something like parties in the middle of a sentence. That typically means that that's being treated as a proper noun, which means that it's a defined term. And contracts often have a lot of defined terms. When lawyers write contracts, we learn to write contracts by defining terms, so you don't have to continue to write out a definition. And then you combine a few combined terms, and you can really make things sound. You can shape the terms of a contract tremendously by the way that you define things. So you want to read the definitions and make sure the definitions in a contract make sense and are workable. And as much as possible, you really want the definitions to match the common usage of the word. The example would be medically necessary. So insurance companies will only pay for services that are medically necessary. Read the definition. If that's capitalized, look and even if it's not, do a search on the document. Look for terms like medically necessary, and then make a determination if that definition fits within the usual and reasonable definition of what's medically necessary. If there's an overly restrictive definition, you want to make a change to that definition. You don't want the insurer creating their own definition of what's medically necessary. You want to make sure that a term like that fits within the generally accepted practice. About that, I think I accidentally muted the microphone. All right. So the term of the contract, as I mentioned earlier, contracts can be the type that have a defined end date. More frequently, however, is you're going to find contracts that have a date that will automatically renew. The termination date will automatically renew unless one party gives notice that they do not wish to renew the agreement. Or sometimes you'll see one that just automatically renews, and if you don't see some language, they'll usually have some language that this contract automatically renews unless one party gives notice to the other at least 60 or 90 days in advance of non-renewal. If you don't see that, then you need to look at the other areas for termination of the contract. It may just automatically renew, and separately you'll have termination language that says that either party can terminate this contract with so many days advance notice, and it's a termination without cause provision. Again, put these dates on the calendar, and also make note that your renewal dates are your opportunity to fix things that you don't like with the contract. Termination, at the end of the term, the contract may terminate automatically, or you may have options to terminate the contract with cause or without cause. When you're looking at termination provisions, if you see termination with cause in particular, or termination for default, or termination for breach, you could use any of these different terms. This is essentially the options for a party to terminate when the other side is not doing what they're supposed to do under the contract. You want to ensure that you have an opportunity for notice and cure with respect to any termination provisions, unless it's something that says, we can terminate you if you're no longer licensed to provide services. Then yes, then the contract it might be subject to. There's certain provisions that may subject the contract to immediate termination. Otherwise, certainly the MCO and the contracting relationship is going to make sure that you have to give them notice. Those notice provisions, notice and cure, they should mirror each other. Too often what we see is, if you want to declare a breach or a default under the contract, you have to give them the MCO 60 or 90 days advance notice, describing in reasonable detail the breach, and give them an opportunity to cure the breach. But if they want to declare a breach, they give you 10 days notice of the breach, and you have just a short window of opportunity to cure. These are terms that are typically flexible in contracts. So while you may not be able to change the basis for breach, you are going to be able to modify oftentimes the time frame that you have to cure. So two big points here on cure. One is you want to allow sufficient time to cure. And again, these should be the same on both sides. If one side has 30 days to cure a breach or a default, then the other side should have the same. The other thing you want to look for is there's certain defaults that sometimes can't be cured within the time period given in a contract. An example of this would be, let's say you're supposed to have a particular accreditation and you're up for renewal, but the accreditation, everything is done, all the inspections, all the site work is completed for the accreditation. You're just waiting for somebody to sign off on it, but it can't be signed off until parties meet for committee, or who knows what the circumstances are. And it's going to be 35 days. And the next meeting, today we're at the end of October, the next meeting of this group is December 1st. And you have a provision that says that the contract is subject to termination if you don't cure this accreditation issue, and you've got 30 days. Well, you need 36 days, and you're just waiting essentially on an administrative task. So you want the contract to have some language to the effect that certain cures that can't be cured within 30 days, you get a reasonable amount of time to extend the cure period, so long as you're diligently commencing to cure. That's sort of the typical language that we look for, or that I'll write in a contract. So long as a party is diligently commencing to cure, then the contract won't be terminated. This won't be for everything, but it will be for certain provisions where there's not an immediate danger. You don't pose an immediate risk to the insurer by continuing the practice and continuing to act under the contract. So you look at your termination with cause provisions and make sure they're evenly balanced. Then also look at the termination without cause provisions. And again, you want these to be evenly. If one side has an opportunity to terminate without cause, then you want the other side you want to be able to terminate without cause. Look at the terms again, see if these are reasonable, if these terms work for you, or if there's things that you need to consider changing. The preference, by the way, if it's time to terminate, on clients, if a client contacts me and wants to terminate an agreement, generally the preference, if all things being equal, would be to terminate without cause, only because you just don't want to pick a fight. If you can walk away from a contract and you have the option to terminate without cause, then that's usually the better option. However, keep in mind that sometimes a termination without cause and a termination with cause will have a different effect. For instance, and this is actually separate from managed care contracts, but in the context of any relationship where there are non-solicitation or non-compete provisions, this is common in employment relationships and similar type relationships. Sometimes we will draft into the agreement. This is what I'll draft: is that if there's a termination with cause by the other party, then maybe a restrictive covenant post termination is enforceable. But if there's a termination without cause by either party, or if I terminate or my client terminates without cause or terminates with cause because the other side breached, then we don't have to honor certain obligations at the end. In the managed care context, it might be an obligation to continue to treat patients for a certain amount of time. There might be a runoff period during which you need to continue to treat. But if the MCO is not paying you and they've just flat out stopped paying you, you don't want to have an obligation that if you terminate the contract for breach because they're not paying you, you have to continue to perform for a certain period of time post termination while this breach continues to go on. If it's if it's an inconsequential breach, it's not such a big deal. Renewal, I've talked about the renewal already. Again, big thing to know here is this an evergreen contract or not? If the termination is that the contract terminates at the end with notice, or the contract will continue to renew unless you give notice and it won't terminate. Look at the notice provisions in the contract. Again, you're probably not going to change these, but you want to make sure you understand where you have to give notice. Also, look at what's listed for you in the contract. Is it an address to which you're going to receive mail? If the notice allows for email, if it allows one party to give notice by email, does it allow both parties? I'm starting to see contracts that allow notice. Typically, notice would have to be in writing by certified mail or registered mail. I'm not even sure who uses registered mail unless it's international anymore. But that's what we would traditionally see. We'll sometimes see fax. If you don't have a fax number, then obviously notice by fax isn't going to work very well. Most healthcare providers do, because that's how we're still often transferring records. But fax is not used as widely as it used to be. We're seeing email for notice. What I like to see for email notice is you can have a certified or a certification of receipt or a return receipt on the email. That usually works pretty well, but there's still some circumstances where an email come through and then maybe a receipt is sent because of the forwarding mechanism in the email. Maybe automatically the email got opened and populated somewhere else, and a read receipt gets sent back even though the email wasn't actually read. What I like to write in the contracts myself is I have a provision that says that email is sufficient provided the other party provides an affirmative response in receipt of the email. So when I send an email, if I'm given notice by email, I'll say something to the effect of, please confirm receipt of this email. If you have a contract that doesn't say you allow notice by email and you give note, you should follow whatever the requirements are. But if you do, you can still send an email to give notice. So you could send it by FedEx or certified mail, but there's no reason why you can't also send it by email, and you also can't ask for confirmation of receipt. Just make sure that both, again, that the provisions are the same. You don't want to be able to be subject to receiving all notices by regular email, and yet when you give notice, you have to do it by, a particular courier or some hand delivery or some other mechanism. You want these to be even. All right, contract amendments. Typically, the contract will say that it can't be amended without both parties' consent in a writing signed by both parties, or the language may say in a writing by the party to be charged, signed by the party to be charged. What that means is that if you have an amendment and I want to enforce the amendment against my counterpart, I'll say, hey, we've agreed to this amendment. Here's the signed amendment, the amendment that you signed. You are the party to be charged. You're being charged with the amendment. You're being charged with the enforcement of the amendment. I've had people ask me, actually, hey, I've got the signed amendment. The other side signed it. Should I sign it? Typically, the answer is yes, unless you're in it may be dictated by circumstances where if it has been sitting in your file and hasn't been signed, maybe it's better not to sign it so you're not altering the document. But typically, if somebody signs the amendment and if it's one that you've requested, make sure that you countersign it, then put it in your file. Sometimes you'll see this language in these MCO contracts. You see them in other healthcare agreements that the MCO or a party reserves the right to make changes for regulatory compliance. I'll write that in the contract sometimes. That language should also include some language that says that if we have to make a change for regulatory compliance, then we'll give you notice of that. The parties will work together to try and make that change. And ultimately, if we can't come to an agreement of what that change should be, we either have a right to terminate the agreement, renegotiate the agreement. If it may be a compliance issue that doesn't necessarily take legal effect until maybe there's a law change at the end of the year or the end of the term, we'll have some language that says that the contract that will continue to operate under the existing contract, but before we renew, this new term will go into effect. Just make sure you look at those provisions very carefully. Anything that gives the other side, anything that gives the MCO the right to unilaterally make changes to the contract, you're going to find these in amendments. You're also going to find this, and we'll talk about this a few minutes later, in incorporated documents. You'll see most MCO contracts will incorporate certain policies and procedures outside the contract, and then they'll reserve the right to amend those policies and procedures from time to time. You want to make sure that those policies and procedures that aren't written in the contract but are incorporated in, once they're incorporated, they become part of the contract. You want to make sure that if those things get amended, you have a right to review those amendments and reject anything that's unreasonable. A lot of times those will just be inconsequential type amendments, maybe a new address that you have to send notices to, something to that effect. But if there's a substantial change, for instance, if you're talking about the procedure for appealing underpayments or appealing recoupment requests, and the original policies and procedures provided a certain procedure where you have, say, 60 days to make a demand for an appeal or reconsideration of a recoupment or an underpayment from the insurance company, you don't want them suddenly changing that to 10 days or suddenly changing the basis, changing the way that you make the appeal. If you originally had to give appeal by just notice and a brief factual statement as to why you're submitting the appeal, you don't suddenly want that to be amended after you agree to the contract, that now you've got to provide notice. You have to provide a detailed statement, an affidavit of an expert witness testifying to medical necessity, etc. Make sure that if there's going to be any other changes, you have the right to review those changes and reject the changes and either continue to the end of the term or renegotiate those changes. And if they're unacceptable, you get to walk away from the contract. Confidentiality provisions, these are common in many healthcare agreements. In the MCO contracts, what's a little bit different here sometimes is some of these contracts will have quality metrics in the contract, or oftentimes in an addendum, or again in an incorporated policy or procedure. And these quality metrics may weigh on how payments are made under the contract. If the MCO is going to be tracking quality metrics, are these things going to be confidential? So you want to look and see under what circumstances can the information be shared, to whom can it be shared, who has the right to share it? Is it just the MCO or is it both sides? You may want to ensure that if the MCO can share quality metrics, that you have an opportunity to review those before they're published publicly, or that you have an opportunity to respond to those. If these quality metrics are something that you don't believe fairly represents the services that you provided for one reason or another, and these are relatively new phenomena, by the way, or in the last few years with more value-based pricing and care and so forth. The quality metrics may not accurately represent what the practice performance is. You want a right to respond to that or make commentary. You want to control how that information is distributed to beneficiaries or distributed to the public. And if it's not confidential, or if there's terms under which that information can be distributed to anybody, you have to, of course, assume, especially in the day of social media and everything else, that anything that can be distributed outside the parties' relationship that isn't absolutely confidential is potentially going to end up in the sphere of general public knowledge. Beyond that, with confidentiality, most agreements will have provisions in there that allow you to discuss the terms of the contract with professional advisors, lawyers, accountants, other consultants who may work with the practice and so forth. Obviously, employees and contractors will have exposure to the information, and those are commonplace. And then there will also be carve-outs for compelled disclosures under a court order and the procedures for that. So if there's information that's confidential, let's say pricing information is often confidential under an MCO agreement, and it may the provisions in confidentiality may make the terms of payment and pricing confidential. What if you get a subpoena and somebody's asking about that, or if you get asked during a deposition what those are? If you are subject to a subpoena or a court order, anything of that nature, before you discuss that information, you want to make sure you look at the agreement to find out what you can disclose. Maybe have a conversation with the MCO themselves to let them know what's going on, or consult with legal counsel and find out, what information can I talk about and what do I need to keep confidential, which may include, by the way, the contract itself. It'll often say this contract or the terms of this contract are confidential. Before you share it, make sure you confirm what information you can share. Dispute resolution. I could spend probably a half hour talking about this. What I'm going to say about it for our purposes is that in over 20 years practicing law, many of that doing litigation, litigation is something the parties generally want to stay out of. So I am heavily in favor of provisions in a contract with an MCO, and I see these oftentimes that provide for some alternative dispute resolution procedures. Some of the most common ones that we'll see in the MCO relationship is first a joint committee or a joint policy committee. This is a team of members from the MCO and of providers who are the first line of receiving complaints or issues with performance under the contract. We saw this a few years ago when some of these were really new, and perhaps this committee meets on a quarterly basis or meets on a case-by-case basis to try and internally resolve issues. And you want to have you want to have buy-in from everybody who has something to be gained under the contract. So you want people, not just the MCO, to have a committee, but you want to be a part of that and be able to appoint somebody or take part in this committee. Typically, this is your first line of negotiation to resolve disputes. Beyond that, some contracts will require the parties to negotiate. Sometimes you'll have what is called a meet and confer requirement, or a face-to-face meet and confer. A telephone call with the other side where two people yell at each other and nobody hears anything, I think is typically a waste of time. If you can have a face-to-face meeting, either in person, or now we can do face-to-face by video, kind of like half of what we're doing today with this, those tend to be more effective. Mediation is where you bring in a third-party mediator. I'm a mediator, and full disclosure, I very much like mediation because it works. In my particular experience practice, I've done a number of mediations where negotiations, probably over half the time, if there's disputes in these negotiations, people walk away, they're unhappy, they threaten lawsuits, they continue with an unsatisfactory relationship, low chance of success. Mediations, in my experience, the ones I'm involved in, probably have about an 80% chance of success. The mediator isn't invested in their own position. Yeah, you've got to pay somebody, but you've got somebody who's a neutral third party who isn't heavily invested in their own position, can listen to the parties on each side and try and help those parties craft a solution to keep them out of a lawsuit. Finally, some contracts will require arbitration. Arbitration is typically binding. It can be binding, non-binding, but typically it's going to be binding, which means it has the effect of a court order. It's just to a private organization, such as there's AAA, the big one for regular arbitrations, and then in healthcare we have AHLA, and that appoints private arbitrators. I am an arbitrator with AHLA, so I can act as a private arbitrator between parties if I get selected that have a dispute and want somebody else to tell them what the answer should be, and that will have the effect of a court. And again, as I put in a practice pointer here, I'm not a huge fan of just negotiation provisions because I often find they don't work. All right, we're going to move into terms unique to managed care. These are things that you won't find necessarily in every contract, but you'll see these in managed care contracts. some unique terms themselves that are unique, and we'll talk about some of the issues that commonly arise. So the first one we're going to talk about here are products. The products are the offerings under the MCO relationship. These can be HMOs, PPOs, under government, Medicare Advantage, or Medicaid managed care. These are the managed care, for instance, in Medicaid. I've had quite a bit of experience with that here in Florida. These are private organizations that operate their managed care program, but they operate it under the statutes and rules that implement Medicaid in the state of Florida. Medicaid is a partnership essentially between the federal government and the states. The federal government helps to fund it. There's certain guidelines under which the funding occurs, and then the states implement the program. In Florida, that program is administered by AHCA, the Agency for Healthcare Administration. Other states do it differently. And then AHCA has an agreement with certain private providers to provide Medicaid services, the Medicaid managed care. So whenever we're talking about different products, things you want to be aware of with products and what applies are reimbursement rates, what the pre-authorization requirements are. Obviously, there's a difference. If you're in an HMO system, you have to get a referral typically from your primary care physician to somebody else that's in network, and they have to make a referral if you want to go for specialist services. When you get into a PPO type system, there's a little bit more flexibility there, where you don't necessarily have the same requirements for receiving pre-authorized approvals. Just kind of looking at some notes here, make sure I don't miss anything. So if you're looking at the managed care products in the contract, take a look and see how certain offerings can change under the contract. Can this be done unilaterally? This goes back to the amendment provision we talked about. If the MCO can make changes, can add products, can add services, obviously there's providers that will come in and out of the system. If the MCO is going to change that, and they're going to have you make additional offerings, or certain things are going to be covered that wouldn't normally be covered that you offer, do you want a right to essentially veto that? You may offer certain services under the MCO contract that you have other services that aren't covered. If those services to be covered, they of course could be at a reduced rate. Are you required to provide those for the MCO beneficiaries, or is that optional? Do you have an opportunity to opt out? Just be aware that when you're looking at the contract, you're negotiating, you really want to give yourself the opportunity to review any changes. If there's going to be a change in products or services, offerings, pricing, procedures, you want the MCO to have to give you notice of that, written notice, as we talked about before, so you have an opportunity to review what those changes are and decide, is this going to be acceptable, or do I want an opportunity? Do I want the ability to negotiate perhaps a different rate structure? Are there other concerns that I have? Similar topic, rates and rate adjustments. You really just need to review these with your business team, or review these, to check out the what the rates are for payment in the contract. Especially look at things like modifiers, which can have a substantial effect on the contract. I've had that issue come up a couple times recently, where the contract modifiers that are not in the contract but in a separate addendum or in separate policies and procedures for coverage of certain items, if the MCO has the unilateral right to change those modifiers, it can have a substantial effect on pricing. Thinking of an example, let's say if you provide services with a certain window of time for a beneficiary, perhaps maybe the subsequent services get reduced by a certain percentage based on a modifier. If you're providing services for multiple beneficiaries in the same setting, the payment rate for services get reduced by a certain percent. If the MCO has the right to unilaterally change these, that can have a substantial effect financially on your performance in the contract. So you want to make sure that they can't do anything. You can't make changes without your approval. And if they do, then you get a chance to renegotiate it. Multi-year contracts, you want to be aware of rates and have escalators in there. The escalators could be based on a set percentage every year. Essentially, the rates go up, or that the rates, to the extent that maybe you tie them to CPI. There's different ways to do it, but you want to make sure that you're not, if it's a fixed dollar amount, that fixed dollar amount is not the same rate 3 or 5 years from now, especially in today's inflationary environment. You want to make sure you're not doing the same services for less money 5 years from now as what you're doing today. This is also something to strongly take a look at, strongly consider, and take a hard look at when you are negotiating a new contract or if you're in a renewal phase. Okay, this is, I could have used this definition. This is an example when I was talking about definitions earlier. Timely submission of clean claims. So clean claim is a term that's entirely unique to healthcare insurance. I don't think I've ever even seen the term clean claim in any other context, even in other insurances or in other contracts. So typically there's going to be a definition of what a clean claim is. So you don't just submit your claims for payment, you have to submit clean claims for payment. That may define the information you have to submit with the claim, the time frame during which the claim has to be submitted. You want to take a look at that. Look at the definition. Look at the procedure for submitting claims. Look at the time frames for once you submit a claim. What's the payment date? How long is the opportunity that the provider has to reject or request additional information? What are your rights to supplement the claims? Sometimes there's state regulations, statutes, or rules that may affect timing for clean claims. If that's the case, you want to make sure that the state standard is the standard that you're working under. Otherwise, you want to make sure that whatever the standard is in the agreement, look at that. Even if you can't modify it, if it's totally unreasonable, you may want to modify it. Even if you can't modify it because it's the same across the system, you want to make sure that you can work with it. And if you can't, then you need to reconsider the relationship. So you have beneficiaries or patients who come in, and some of them have certain covered services. And as I mentioned earlier, you may have services that you provide that aren't covered under the agreement. Do you have the right to bill patients for those? You don't want a restriction in the agreement that says that you can only bill beneficiaries for covered services and you have to eat the costs on the others, or you have to pay, you have to settle for a reduced rate on the others. Sometimes the providers will make a note in the medical record with respect to additional recommended services or additional services that are provided or recommended to be provided, get the patient's consent to provide services that are not covered services under the contract. Does that suffice? Do you need a specific form? If there is a certain way to bill for non-covered services in the contract, you want to make sure that that's reasonable. You want to make sure you don't have overly onerous requirements to be able to bill for non-covered services. And you want to ensure that if you bill for non-covered services, there's a way to recover that payment. You always want to have a way, if the insurance company isn't paying for the services, that you can charge the patient. You provided the services, you're entitled to be paid. If you can't come up with a standard form, if the form is too onerous, then you can go to a government standard, like under Medicare Advantage Care or under the Medicaid forms, and find one of the forms that works and adopt that form for use in the practice. Again, just something to consider as you're negotiating for these items. Retroactive claim denials. You want to limit the time that the insurance company can retroactively deny a claim because somebody isn't not covered, essentially. So take a look at what the claim denial period is and try and limit to a maximum number of days the time frame after which you provide the services. What's the time frame that the insurance company has to come back and say, we're not going to pay that? And again, you want to reserve the right in the contract. Make sure that there's nothing that prohibits you from billing patients. If somebody comes in and you provide services to them, it turns out that they're not covered, you want to make sure you can go bill the patient directly for those services. So make sure nothing prohibits your right to do that. All right, overpayments and underpayments. I'm going to do probably an entire seminar on this. I think next month we're doing one for another group. If you get an opportunity to sign up for that, we're going to talk about underpayments and recoupments. So what is important here is that you want to make sure that timing, first of all, for challenging any payments is equal on both sides. If you have a 30 or a 60-day window to challenge the MCO because they have underpaid you or have not paid you on a certain claim, you want to make sure that the MCO has the same window as much as you can. You want to negotiate that. Look at the time frame for making underpayment and overpayment demands. You don't want to be in a situation where you provided services and then you're finding out, 16 months later, you get some letter from the MCO saying that you've been overpaid. I've seen this, by the way. This seems to be more commonplace ever since Medicare stepped up their game several years ago in conducting overpayment audits. Medicaid has jumped on that bandwagon, and I'm seeing more and more in the Medicaid managed care system audits and claim denials or audits and claim recoupments, where the insurance company has already paid you, and now they're saying we've overpaid you. You need to return the money to us in a certain amount of time. Not only do you want to look at the timeframes for underpayments and for recoupment demands, you want to make sure that you have a fair appeal right. And I mentioned earlier, policies and procedures that are oftentimes referenced outside of the agreement. Make sure you look at the policies and procedures for claim denials, for overpayments, underpayments, appeals, redetermination, appeal rights. And here's the key of what you're going to be looking for is with respect to any of these challenges, you want some mechanism for resolving these payment issues that goes beyond the MCO. You don't want to get into a dispute with the MCO about payment and the right to payment, where the MCO and you are on opposite sides, and the MCO is the final arbiter of that decision, or the MCO hires a contractor to be the final arbiter of that decision. You want an independent third party. And if you can't resolve that issue with the MCO on any of these overpayment or underpayment issues, then you need to look to your dispute resolution procedures. That's back to the negotiation, mediation, things that we talked about earlier. You want a mechanism as simple as possible. You don't want to have to file a lawsuit because you didn't get paid. You want a way to challenge these to get somebody on the line. And I say that from experience in dealing with insurance companies on payment issues. If you can get a decision maker into a face-to-face conference, you can often get these things worked out. I don't know if that's a lawyer thing or if parties can do it themselves, but we've often been able to have success dealing with these payment disputes once we get the attention of somebody on the other side that has authority to make decisions on these. All right, policies and procedures. I'm looking, I got 5 minutes. We're doing pretty well. I mentioned this earlier. Whenever there are policies and procedures that you'll see language incorporated by reference, or the policies incorporated, policies available at www, everything on the website. Look for whether those are incorporated as contract terms. They often are. And then the way you want to be able to handle those is that any changes to those policies and procedures, you want an opportunity you want to have the MCO give you notice in advance, opportunity to review any changes and reject those changes, either in the form of continuing under the current agreement until the end. And they may even have some language that says, if you reject it, you continue under the current agreement. Once that agreement renews, you thereby adopt those new policies and procedures. I'm okay with that. That's fair. They're basically saying, we're going to change the policy. We're giving you notice now. If you don't reject it and this agreement renews, either because it's going to automatically renew or because you opt to renew it, the new policies automatically take effect. Be aware of that. But you at least want an opportunity to review those. Here's a practice pointer on policies and procedures. Everything you read, if you get a book or an article or a seminar, and I can sit here and I can say, you need to go out and you need to read all those policies and procedures. Anybody who's actually tried to do that, first of all, I don't think you're going to absorb it all. Typically, what you're doing is you're referring to the policies and procedures when it's time to deal with something. Payment issues is a perfect example. You have a dispute. Now you want to see what the appeal procedures are. Now you're going and referring to the policies and procedures. If you can't go out and review everything, which I don't think is practical advice, try to have some language, at least have language in the contract that says that the MCO's reasonable policies and procedures are incorporated, or some language to that effect. Then you can argue later over whether something is reasonable or not reasonable. So that's like a little contract hack. Whenever a party on the other side, the MCO has sole discretion for something, for amendments, for policies, procedures, rules, etc., you want that discretion not to be their sole discretion. You want a reasonableness standard in there. that at least gives you something to hang your hat on later that you can take a position on. With respect to adding or removing parties or locations, providers or locations rather, you just need to understand what the contract requirements are. Do you have to notify the MCO of any changes and get their approval? Or is it just a notice, or is it notice and you have to wait for their approval? You need to figure out what the requirements are, and as much as possible, you want to be able to bring providers into the practice and have them start billing right away. Same thing for new facilities, new technologies, new services. You also need a mechanism to bill for additional services. An example here would be, let's say you expand your services, you expand telehealth, expanded over the last few years, and you're expanding your telehealth services, and the contract doesn't specifically spell out how to pay for those services. You need some reasonableness standard, a way to be able to provide for payment for enhanced services. And ideally, there's going to be some mechanism that says that you'll either negotiate those at a fair rate, or you'll use some standard like Medicare or some third-party standard that is fair. If you're taking on new facilities or locations, if they already have a contract with the MCO, you want to try and bring everybody under the same contract. So maybe as part of the due diligence process, you look and see what are the most favorable provisions. Let's try to operate under that contract. So keep that in mind if you're acquiring, for instance, or you're partnering up with another practice, or you're bringing somebody who's already in the MCO's system. You want to bring everybody under the same umbrella. Here I put an example using telehealth that you can read through. I'm not going to read this to you, but the idea is that if you have enhanced services and you're improving your services to patients, you want a mechanism. Again, the concern here is that if you're doing more, you want to be able to get paid for that. And you want the contract to account for the fact that you're entitled to get paid. Ownership changes, this is a big issue. Thing I'm going to say on this is if you're selling a practice or you're changing ownership in some way, you're bringing in a new owner of the practice, really a good idea to bring in legal counsel, look at the contract, see what's required, see what the assignment provisions or the change of ownership provisions are. If you're dealing in Medicare, Medicaid, both of those, by the way, have their own procedures for changing ownership of the practice. So make sure you review the contract and understand what those change of ownership procedures are. Quality provisions. I mentioned some of these earlier. Review whatever the quality standards are. These may be in a contract. Oftentimes they'll be an addendum, or they'll be in a separate policy and procedure guide or manual. Look at those. You're really looking at these to make sure that they're reasonable. Make sure that you can meet these standards and terms, and there's nothing particularly onerous. And then again, look at the confidentiality provisions and see how these things can be shared, and who has access to the information, and what are your rights to challenge or add an addendum or add some type of commentary to the standards, and how much does this stuff affect the way that you get paid now or in the future. Government contracts. I'm not going to have a chance to really get deep into the government contracts, but a lot of the issues that we talked about as far as the contracting are the same. A couple that I'll talk about here, the Medicare Advantage. Looks like we're at 1 o'clock. So if anyone wants to stay on, I'll finish for 1 minute here. I want to just point out that sometimes on some of these contracts, both state and federal, you'll have standards from CMS, or in Florida, you'll have standards from ACA that have to be incorporated into the contract. You want to make sure that if there's state or federal standards, the contract aligns with those standards and is something that you can perform, and it's not more onerous or more stringent than what the standards are. All of these contracts will often have some requirements for compliance training, and you want to make sure that you're complying with that compliance training, with risk assessments and so forth. Sometimes you have to have, like in Florida, you have to have an emergency management plan and so forth. Make sure that you are meeting whatever the requirements are under the state or federal law for those contracts, in addition to the contract performance. I'm going to skip here to a couple of these if you want to look at the slides, if you have any questions. We're going to look at implementation. I talked earlier about making notes in the contract themselves of the updates that are coming up. Make sure that your team is aware of the contract, is aware of contract performance. People that are responsible for these items in your office, make sure you go over this and you have a plan for implementing what's required under the contract. you're meeting all of the compliance standards that are required under the contract, with certain reporting standards. And this is where, once the contract is being implemented, you really want to be proactive. This kind of leads us into this seminar. I did one a few months ago, and I could do this again, on essentially risk management, avoiding issues, getting in front of issues and disputes, both in contracts and otherwise. And if you take the risk management seminar that I did a few months back and add it on to the end of this seminar, then you're going to get a continuation of running the practice and keeping yourself out of trouble. And with that, we wrap up. I don't really have time for questions, but I would encourage you, if you have questions, reach out by email. My contact information is below down here, or by phone. Happy to talk about these items in more detail. And I look forward to seeing everybody next month on the next seminar, talking about, I think we're doing payments and payment audits and how to get paid and keep your money as a provider. Have a great rest of your day. Bye-bye.